I was reading through a legal case file recently coming out of Switzerland, and the details of it were so chilling they actually made me pause. It didn't start like a horror story. It started with a completely standard, responsible domestic scene. You had two parents deeply worried about their teenage daughter who was struggling with her identity, doing exactly what good parents are supposed to do. They went to the professionals. They sought mental health support to help her navigate her confusion. You can almost picture their mindset walking into that situation. They were expecting a partnership, believing that the school and the authorities would help them stabilize their child. But then came the turn, and it was brutal. The authorities didn't offer therapy. They demanded a social transition. And when these parents pushed back, refusing to co-sign on what they viewed as a path to irreversible physical harm, the state didn't just disagree with them, it replaced them. Citing a specific article of the Civil Code, social services physically removed the daughter from the home. One day she was with the family that raised her. The next, she was living in a government shelter, effectively seized by the state because her parents refused to affirm an ideology they didn't believe in. That sudden, violent shift from a family seeking help to a family being dismantled by the very bureaucrats they turn to is terrifying. It exposes a new, silent logic running through our institutions, the idea that your children are only yours until you disagree with the government. And the scariest part isn't that this happened, it's that under the current laws, the system was working exactly as intended.
Wow, I mean, that story, it just perfectly frames what we need to dig into today, doesn't it? It's the absolute core of the mission for this deep dive.
It really is. It's this collision of family, state, and ideology.
Exactly. And that case, along with, a growing number of similar conflicts we're seeing across the West, sets the stage. We're going to be doing a critical examination of this incredibly complex balance between parental sovereign rights, the right to raise your own child and state intervention, especially when it comes to a minor's gender identity.
So it's the fundamental question, right? Who has the final say over the future of a child? Is it the parents or is it the state?
Precisely. And that's why this deep dive is going to take us into this legal and ideological battleground. We're going to be looking at where parental rights clash with state interests and this very new and frankly volatile idea of a minor's expanding autonomy.
Okay, so where do we start?
We'll dig into European case law, which is where a lot of this is being stress tested right now. We'll also trace it back to the foundational principles in American law, both constitutional and common law. And then we have to look at the sociological angle, this argument about ideological capture of institutions, what one of our sources calls a woke bureaucracy.
Let's start right there then. Back to Europe with that Swiss case you just laid out. It's just so extraordinary because it's not about abuse. It's not about neglect in the traditional sense. It's the state stepping in over an ideological disagreement.
That is the absolute crucial distinction. It's a paradigm shift. According to the family's lawyer, this felt less like child protection and more like, state-sanctioned kidnapping over an idea.
Can you give us a little more detail on the sequence of events? The parents went looking for help?
Right. They went in good faith. They have a teenage daughter who's struggling, confused about her identity. So they go to the authorities expecting, a therapist support. What they got instead from the social services was a demand.
Not a suggestion, a demand.
A demand for immediate social transition. That means using a new name, new pronouns, a whole new social presentation for their daughter. No therapy first, just immediate affirmation.
And when the parents hesitated, when they said, hold on, this seems like the first step on a path to irreversible physical changes, the state didn't offer to mediate, did they?
No. The state's response was, in effect, culture replacement. They cited a specific article in the Swiss Civil Code that allows for this kind of intervention. And then they physically removed the daughter from her home.
Took her.
Put her in a government shelter. The family unit was dismantled, and the reason given. The parents refused to affirm an ideology that they believed, in their core, was not in their child's long-term best interest.
It's a whole new definition of parental fitness then. It's not about providing food and shelter anymore. It's about ideological conformity.
That's the new silent logic at play. And the lawyer's observation was just so powerful. He said that no free society should ever allow parents to lose a child solely for affirming biological reality.
It's chilling. And it seems like this isn't just a one-off case in Switzerland. We're seeing similar, maybe more subtle mechanisms to get around parental authority in other places. Portugal comes to mind, especially inside the school system.
Yes. Portugal is a really key example of how this battle is shifting into the educational sphere. They're leveraging this idea of school autonomy to, in many cases, circumvent parents entirely.
And this centers around a specific law, right?
It does. It's Law 3820-018. And what this law mandates is that schools must guarantee respect for a child's expressed gender identity. In practical terms, that means allowing for social transitioning within the school walls. New name, new pronouns, new gender presentation, all approved and facilitated by the school.
So a child could essentially be living one identity at home and a completely different one at school, and the parents might not even know about it.
That is the absolute heart of the conflict. You've hit it exactly. Legally, a formal name change for a minor in Portugal still needs parental consent. But the on-the-ground implementation, as they call it, the day-to-day reality in the school, that's where the friction is.
I can see why it creates this fundamental split in a child's life.
It does. And the fear for many parents is that the child they send to school in the morning effectively ceases to exist once they're on school grounds. They're replaced by this new identity, one that's been forged and affirmed not by the family, but by the school system, by the bureaucracy.
Has there been any pushback against this politically?
Oh, absolutely. The tension really came to a head in January of 2024. A new bill was put forward to try and solidify this power even more, to give schools the explicit authority to make these decisions for kids under 16 without any parental involvement.
And what happened?
The president of Portugal actually vetoed it. It was a major move, a real check on that institutional power.
Yeah.
That veto sent a strong signal that there's significant political resistance to the idea that the state or its institutions like schools should be the main decider of a child's social identity.
It really underscores that this isn't just about medical procedures. It's about the right to know what's happening to your child, to guide their social development, which I think is the perfect bridge to the UK case, Ray J. That one blew the doors open on the whole question of consent and the quality of medical care.
Ray J is absolutely crucial because it wasn't just another dispute between parents. The court ended up doing this incredibly deep forensic dive into the kind of medical treatment minors are getting from these unregulated online clinics. It's a shocking case.
So let's get into the details. Ray J, the judgment came down in May 2024. We're talking about a 16-and-a-half-year-old born female who identified as male and had already started taking testosterone.
Correct. And the father was against it, the mother was for it. But the real story here became the clinic that was providing the hormones. It's an offshore online clinic called Gender GP. And the court brought in an expert witness, Dr. Jacqueline Hewitt, a consultant pediatric endocrinologist from Australia. Her testimony was devastating.
It wasn't just a minor criticism then.
It was a complete indictment of their entire clinical model. Dr. Hewitt laid out 4 massive failings. It was just a profound lack of basic medical care.
Okay, walk us through them. What was number 1?
First, Gender GP never conducted a physical exam. Not before prescribing powerful hormones and not after. Nothing.
For a growing teenager.
For a growing teenager. Second, they failed to do any specialized bone scans, bone age x-rays, bone density tests. These are vital because testosterone dramatically impacts how a young person's skeleton develops. They just skipped it.
That sounds incredibly reckless. What else?
Third, the psychological assessment was, in her words, of extremely poor quality. It was just a single online session. And the person who did it was a counselor who wasn't even registered with the main professional body, the HCPC.
So a single online chat with an unregistered counselor.
Right. And fourth, and this is just astonishing, there was no record of any counseling at all about the known serious risks of the hormone treatment. They just didn't mention them.
The lack of basic medical checks is bad enough, but I remember the dosage was the thing that really stood out as shocking.
The dosage. Dr. Hewitt called it highly abnormal and frankly negligent. That was her expert medical opinion.
And what was it specifically?
They prescribed Jay an intramuscular injection of testosterone called Nebido. The dose was 1,000 milligrams every 6 weeks.
And is that a normal dose?
It's a top-end adult maintenance dose. It's the kind of level you might reach after 2 or 3 years of slowly building up from a much lower starting point. But Gender GP prescribed this peak adult dose to Jay, a child who had never been exposed to testosterone before, from day one. And to make it worse, they started with a loading double dose.
A double top-end adult dose for a child? That just sounds profoundly dangerous.
Dr. Hewitt said with confidence that no professional society of pediatric endocrinologists anywhere in the world would see this as anything other than negligent. She even stated that this kind of treatment would be unlawful in her home country of Australia because of how reckless it was.
Were there actual measurable health consequences for Jay from this?
Yes. Her blood test showed that her testosterone levels were staying extremely high for months. Normally, you have what's called a trough level, the lowest point your hormones hit right before the next dose. Her levels were supposed to drop to around 10 to 15 nanomoles per liter. Jay's were consistently in the mid-20s.
So her body was just saturated with it.
Constantly. Dr. Hewitt concluded that the hormone was accumulating in her body because of the repeated overdosing. It never had a chance to return to a baseline. And that led to the gravest concern of all, the impact on her bones. Prolonged high levels of testosterone could seriously and irreversibly harm her skeletal development.
This is a horrific medical backdrop for a legal case, and it brings us right to the core legal problem because Jay was over 16. That changes everything, doesn't it? It's about her capacity to consent versus her parents' rights.
It's the central legal knot. Jay, being 16 and a half, brings in the UK's Family Law Reform Act of 1969, specifically Section 8, which gives minors over 16 a certain capacity to consent to their own medical treatment. But that then has to interact with the Children Act of 1989, which is all about parental responsibility. It's a legal minefield.
Okay, let's try to untangle that. How does parental responsibility work if one parent says yes and the child is over 16?
So under the Children Act, parental responsibility continues until the child is 18. And Section 2.7 of that act says that if two people have that responsibility, each of them may act alone and without the other.
So normally the mother's consent would have been enough.
In a normal medical situation, yes. Even with the father objecting, the mother's consent could have been sufficient. But the court has the power to step in under what it calls exceptional circumstances. For a child over 16, though, that power is very limited. The court has to be convinced the situation is truly exceptional.
So the father's whole case rested on proving that this wasn't just a simple disagreement. He had to argue that this situation, this specific treatment, was so exceptional that a judge had to intervene.
That was the core of his legal argument. He was pushing for a very broad ruling. He wanted the court to declare that for cross-sex hormones for any minor, court approval should be mandatory if one parent objects.
Regardless of the child's age or the other parent's consent.
Exactly. He wanted the court to step in if a parent disputes the child's Gillick competence, or the diagnosis itself, or the treatment.
Okay, hang on. For anyone not deep in UK family law, what exactly is Gillick competence? Can you break that down for us?
Of course. Gillick competence is a really important common law principle in the UK. It basically says that a child under 16 can legally consent to treatment if they can show they have sufficient understanding and intelligence to comprehend fully what is proposed.
So they have to really understand the stakes.
They do. And the father's argument here was that for a decision as massive and irreversible as cross-sex hormones, that bar for understanding for Gillick competence has to be set incredibly high. So high, in fact, that if a parent challenges it, only a court can decide if the child truly meets it. He was saying this belongs in a special category of decisions, like turning off life support or sterilization. That always requires a judge's approval.
He's arguing for a mandatory judicial backstop for irreversible physical change. So what did the court ultimately decide?
Well, the judge, Sir Andrew McFarlane, who's the president of the family division, was incredibly cautious. He deliberately limited his ruling. He said, look, the only thing I'm deciding today is the next immediate step, which is to get Jay an assessment from a proper, reputable clinic. In this case, a new one called Gender Plus.
So he sidestepped the bigger legal question.
He did. He said it was inappropriate for him to rule on the father's wider case. He argued the law here is so new and so sensitive that the court must be particularly cautious not to be drawn into academic discourse. He basically said, that's a job for Parliament, not for me.
But he didn't stay neutral on Gender GP, the clinic that was providing the hormones.
Oh, not at all. He gave what he called a firmly given preliminary indication of very significant concern about Jay getting treatment from any offshore, online, unregulated private clinic like Gender GP. He went even further. He directly urged any other court that has a case involving Gender GP to proceed with extreme caution before exercising any power to approve or endorse treatment from them. He was basically putting up a giant red flag for the entire judicial system based on the safety concerns Dr. Hewitt raised.
So even though it wasn't a formal ruling, it was a huge judicial warning. And it shows the state's interest in preventing harm, even when a parent and a 16-year-old consent.
It does. It sets the perfect stage for our next section, really. Because if the default legal position allows one parent to consent to this kind of treatment, it makes you ask, where did the idea of parental sovereignty, of the family as a protected unit, go? And to answer that, we have to look at the very foundation of the family in Western law.
Right. Well, we need to go back to the source code, so to speak, back to the common law tradition.
Absolutely. The idea that the family is a protected sphere, shielded from state interference, isn't new. It's ancient. It's deeply rooted in the common law, and it was probably best codified by William Blackstone.
Okay, Blackstone's Commentaries. A foundational text. What did he lay out as the legal basis for a parent's authority?
Blackstone focused on 3 duties that parents have to their children. He saw them as inseparable. First, maintenance, which is financial support. Second, protection, meaning physical safety. And third, education, which for him meant moral and intellectual development.
And the whole system was based on the idea that they're children. They lack the experience to make big decisions.
Exactly. The presumption was that children lack the reason and experience for critical, life-altering choices. So parental authority wasn't just a right, it was a duty to guide the child and cultivate their virtue and reason until they were mature.
And this framework, this idea of the parent's duty and right to educate, was directly imported into American constitutional law, wasn't it? It became a protected right.
Yes, that's where it got its real power in the U.S. context. It was enshrined as a fundamental liberty interest under the 14th Amendment. You really see this in 2 huge Supreme Court cases from the 1920s.
Let's start with the first one, Meyer v. Nebraska.
Right, Meyer. In 1923, the Supreme Court struck down a state law that banned teaching foreign languages in schools. The court said that the liberty protected by the Constitution includes the right of parents to establish a home and bring up children. It was a powerful defense of a parent's right to choose how their child is educated.
And that was followed up just 2 years later by Pierce v. Society of Sisters.
Pierce was even stronger. It struck down an Oregon law that would have forced every single child to attend public school, effectively outlawing private and religious schools. And the court's language was just so clear. They said the law unreasonably interferes with the liberty of parents and guardians to direct the upbringing and education of children under their control.
And then came that famous line.
The one everyone quotes, "The child is not the mere creature of the state." The court said that the people who nurture the child and direct their destiny, the parents, have the right and the high duty to prepare them for their future. This really cements the family as a sovereign unit, protected from the state.
Okay, so the foundation is incredibly strong. Parents have this fundamental right to direct their child's upbringing, but it's not absolute. There have to be limits. When can the state legally intervene and overrule a parent?
That's the million-dollar question. Parental authority, while it's very broad, is not unlimited. The state can step in when there's what the law calls a compelling interest. Historically, that meant clear-cut cases of abuse or neglect. But the battle today is over whether gender transition treatment rises to that level of harm, creating a compelling state interest to intervene.
And even among judges you'd think would be aligned, there's a deep split on this. The Troxel v. Granville case is a good example.
It's a perfect example. It was a case about grandparent visitation rights, but it really exposed the fault lines in how conservative justices view parental rights. You had Justice Scalia on one side.
Right. His view is that parental rights aren't actually in the Constitution, so they're not really fundamental in the same way.
Exactly. He argued that since they're unenumerated, not written down in the text, the state legislatures have a lot of power to set limits. So, under Scalia's logic, if a state passed a law banning transition treatments for minors, that law would probably be upheld, even if the parents wanted the treatment. It becomes a political decision for the legislature, not a constitutional right for the parent.
That's a very different take from Justice Thomas, who was also on the conservative side of that case.
Very different. Justice Thomas grounds parental rights in the deep history of the common law, giving them a lot of weight. But, and this is the key, he still says that a state's compelling interest could be strong enough to overrule a parent's decision, especially in an area like public health regulation.
And this is where the really powerful, and I have to say controversial, argument about eugenics comes into play as that potential compelling interest.
It's a critical and, you have to admit, very complex legal strategy. The argument is this. Since gender transition treatment for minors can lead to sterilization or seriously damage reproductive organs, you could frame it as a form of gender eugenics.
So the argument is that by consenting to this, a parent is potentially sterilizing their child before the child is old enough to understand what they're giving up.
Precisely. They're taking away the child's future choice to have a family of their own. And that's where Justice Thomas's opinion in another case, Box v. Planned Parenthood, becomes so relevant.
How does that connect?
In that concurrence, Justice Thomas wrote about the state's compelling interest in preventing abortion from becoming a tool of modern-day eugenics. By drawing an analogy, one could argue that the state has a similar compelling interest in preventing the uninformed sterilization of minors.
So that becomes the state's justification for intervening.
It could be. It reframes the whole debate. It's no longer just about parental liberty versus the child's autonomy. It becomes about the state's duty to protect its future citizens from an irreversible decision that has profound consequences for the individual and, you could argue, for society at large. That might just be the compelling interest needed to survive the highest level of legal scrutiny.
It's just fascinating how a principle designed to protect parental rights could also be the very thing that limits them, depending on how you frame the harm. And that brings us to the child's role in all this, separate from the parents, the maturity conundrum.
Yes, the mature minor doctrine. It's this idea that, contrary to the old common law, some minors actually do have the capacity to consent to their own medical treatment if they can show they truly understand what's involved.
And those who argue for more minor autonomy often point to the judicial bypass system, which was set up for abortion cases.
Right, from the case Bellotti v. Baird. The idea there is that a minor can go directly to a judge, bypassing their parents, and prove one of two things. Either that they are mature enough to make the decision on their own, or, even if they aren't, that the procedure is in their best interests.
But the argument against applying that to gender transition is pretty strong, isn't it? It mostly comes down to timing.
It does. Abortion is, by its nature, a time-sensitive issue. The argument against extending the bypass to transition treatment is that it's fundamentally not time-sensitive. It can wait until the child turns 18 without any irreparable harm. The critics say that if the child is truly certain, they can just get the treatment when they become a legal adult.
And there are actual cases where courts have stepped in and said, no, this transition is not in the child's best interest.
Absolutely. The Ohio case Smith v. Smith is a really stark example. A court actually transferred custody of a child from the mother to the father because it seemed the mother was heavily pushing the child, a boy, to transition to a girl. The court's ruling was explicit. They said the child needed to be in a home where he could just be a boy, and then he could make a sober adult decision when he was older.
So courts are already pushing back against this idea of it always being in the child's best interest.
They are. And if you want the clearest judicial analysis of why minors are seen as lacking capacity for these huge decisions, you have to look at Roper v. Simmons.
The case that banned the death penalty for minors.
Exactly. And in that decision, the Supreme Court laid out three key differences between adolescents and adults. First, they said juveniles have a clear lack of maturity and an underdeveloped sense of responsibility. They're impulsive. Second, they're much more vulnerable to outside pressures, peer pressure, social media, activist influence. And third, and this is maybe the most important point for this topic, a juvenile's character is still in flux. It's transitory. They're still figuring out who they are.
And if your whole identity is still forming and changing, making a decision to permanently alter your body seems premature, to say the least.
It connects directly. All these legal principles, the history of parental rights, the state's interest in preventing harm, and the court's own analysis of a minor's capacity, they all point towards extreme caution and judicial oversight. But it seems like all of these legal firewalls are being systematically bypassed by something else entirely, an ideological movement inside our institutions.
That's a huge transition, but a necessary one. We've laid out the legal architecture that's supposed to protect the family. But the argument from political science and sociology is that this architecture is failing because the institutions themselves, the schools, the government agencies, have been captured by an ideology that's actively hostile to it.
That's the core of the critique, yeah. It's the narrative of the rise of the woke bureaucracy. The argument is that these government bodies, these activist groups, these education departments, they've been taken over by an ideology that sees the traditional family unit as an obstacle, maybe even a site of oppression.
And so they actively work to undermine parental authority. It's not just a gradual societal shift. It's a deliberate, top-down effort to dismantle traditional norms.
And according to this analysis, that creates what sociologists call anomie, a breakdown of social bonds. The administrative state then steps in to fill that vacuum. The bureaucracy sees the family not as something to be preserved, but as a problem to be managed or circumvented to achieve its own ideological goals.
And you can see this conflict playing out in real time in the U.S. Congress and things like the annual appropriations bills.
Yes, the proposed House appropriations bills for fiscal year 2024 are a perfect case study. It's a clear attempt by one political faction to, in their words, rein in this woke and weaponized bureaucracy.
So what are some of the specific things they're targeting?
Well, they're going right at the funding. There are provisions to stop any taxpayer money from being used for gender transition procedures for adults or kids, and they're citing the lack of strong evidence that these interventions actually improve mental health or prevent suicide. They point to studies showing no real advantage from surgery in the long run.
So the official argument is about fiscal responsibility and a lack of evidence, but there's obviously a huge cultural symbolism to this as well.
Oh, it's absolutely a culture war battleground. The bills also go after funding for things like drag shows. They cite a specific State Department grant of over $20,000 for drag performances in Ecuador and a drag show held on an Air Force base. They're also trying to ban the Progress Pride flag from being flown on federal buildings, arguing it violates the U.S. flag code.
It's just wild that a fight over multi-billion-dollar healthcare funding is happening in the same bill as a fight over a $20,000 grant for a drag show in another country. It really shows how wide-ranging this ideological conflict is.
And it extends to foreign policy, too. A major goal of the current administration, according to these sources, is to export this gender ideology globally through foreign aid. The proposed bills try to strip all of that out. They want to defund the Gender Equity and Equality Action Fund and get rid of the Special Envoy for LGBTQI plus persons.
So it's a multi-front war, domestic healthcare, cultural symbols, and foreign policy. But you could argue the most intense battle of all is happening in our schools.
I think you'd be right. And for that, the perfect example is the huge controversy over the elementary reading curriculum in Ontario, Canada. It's a perfect illustration of this clash between evidence-based learning science on one hand and ideological critical theory on the other.
This all started because of a report about a literacy crisis, right? The Right to Read report.
Yes, a report from the Human Rights Commission, no less. It basically accused the province of ignoring decades of proven science on how to teach reading things like systematic phonics and direct instruction. It argued they were focusing too much on sociocultural issues and inquiry-based learning, and as a result, they were denying kids their basic right to literacy.
So it called for a big shift back to evidence-based, teacher-led instruction. What happened when the government tried to write a new curriculum to fix it?
This is where you can almost quantitatively measure the bureaucratic capture we've been talking about. A group of analysts did what's called a bibliometric terminology mining study. They did a quantitative audit of the language in the new 2023 curriculum versus the old one from 2006.
Wait, a quantitative audit, how does that even work? And how do we know the numbers are meaningful?
It's pretty sophisticated. They use text analysis software to count the frequency of specific keywords. They created a list of terms associated with learning science like decoding, fluency, direct instruction, and another list for critical theory, systemic racism, decolonization, co-construction, and of course, identity. Then they counted them up in both documents and adjusted for length. The results were staggering.
Okay, give us the numbers again.
So the good news for the reformers was that the use of learning science terms did double in the new curriculum, but that was completely swamped by the ideological language. The use of critical theory terms went up by 335%.
And what about the word identity?
The term identity increased by 2,233%.
2,000. That's just unbelievable. It's not a shift. It's a total transformation of the document's focus.
That's the argument. The conclusion drawn from this data is that the bureaucrats were basically paying lip service to the science while saturating the entire curriculum with critical theory concepts. They were functionally sabotaging the reform from within by completely changing the priority of the school.
And the source material argues that these two approaches to teaching are just irreconcilable.
They're seen as polar opposites. Critical theory wants student-centered, inquiry-based learning that focuses on lived experience and exploring identity. Learning science demands teacher-centered, direct instruction of a carefully sequenced body of knowledge. The new curriculum tries to jam them together, and the argument is that it just doesn't work.
And who gets hurt the most when this happens?
Well, the argument from the learning science advocates is that it's the most disadvantaged students who suffer. Inquiry-based learning relies a lot on the cultural and economic resources a child already has from home. If you don't have that background knowledge, you're lost. Direct instruction, on the other hand, gives every child the same foundational knowledge, leveling the playing field.
So by focusing so much on identity and decolonization, the school is actually failing at its core mission of teaching kids to read and write, and it's widening the achievement gap.
That is the charge. The school stops being a place of education and becomes an agent of ideological transformation. And this perception of institutional capture is what has fueled the explosive growth of the new parents' rights movement.
Right. And this isn't the old school movement of just trying to opt your own kid out of sex ed class.
Not at all. This new movement, which really blew up in the media around mid-2021, is much more ambitious. They are trying to reshape the entire public school environment for all children to push back against the institutional orthodoxy.
And they're getting actual laws passed, especially around gender identity and pronouns.
Yes. Between May 2022 and June 2023, 10 states passed laws that say school staff can disregard a student's chosen name or pronouns if they want to. And crucially, 6 of those states now have laws that require the school to notify parents if their child asks to be called by a different name or pronoun.
Which is a direct counterattack against that Portuguese model of socially transitioning kids in secret.
It is the policy manifestation of that pushback. It all comes back to that foundational principle we started with. Parents demanding their sovereign right to raise their children according to their own values without the state or the school interfering.
So we've seen the battle lines drawn at the national level, in the courts, in the schools. Let's zoom out one last time and look at the global legislative trend that's really setting the terms for this whole debate. Gender self-identification.
Right. We need to be really clear on what gender self-identification or self-determination means. It's the idea that your legal sex is determined simply by your own internal sense of gender identity. That's it. No doctor's note, no judge, no surgery required.
It removes all the gatekeepers.
It removes them entirely.
And who is the first to go down this path?
Argentina. They passed their Ley de Género way back in 2012. It was revolutionary at the time, and the World Health Organization held them up as an exemplary model for transgender rights.
And Europe has been catching up fast.
Extremely fast. As of this year, November 2024, there are now 12 countries in Europe that have legal gender recognition based on self-determination. We're talking about Belgium, Denmark, Finland, Germany, Iceland, Ireland, Malta, Norway, Portugal, Spain, Switzerland, and Luxembourg. It's a huge block.
A significant part of the continent. But how do these laws handle minors, given everything we've talked about?
The rules are all over the place, which really shows the tension. For example, Switzerland, the country from our opening story, their civil code lets anyone 16 or older change their legal gender with no parental consent needed at all.
So a 16-year-old can do it on their own?
In Switzerland, yes. Ireland is a bit different. They have a minimum age, but a 16 or 17-year-old can get a court order to exempt them from that minimum age, so there's still a judicial check.
So this framework of self-ID is already the law of the land in many of these places, which creates the legal environment for the kind of state interventions we're seeing. What's the human rights perspective on this?
Well, the major human rights bodies, like the UN and Amnesty International, are pushing very hard for this. They want quick, easy, transparent self-ID procedures everywhere. They argue that requiring medical or psychological gatekeeping is discriminatory and a violation of human rights.
But there is a very vocal counter-argument, often from feminist groups and others, about the potential risks of removing all safeguards.
Yes. The critics of self-ID raise concerns about what they call the erasure of cisgender women's concerns. They worry about the integrity of single-sex spaces like women's shelters, prisons, or sports. They often bring up scenarios where they believe bad actors could exploit these laws.
And what's the response from the human rights community to those concerns?
The UN's independent expert on this issue has pushed back hard. The expert's report stated that these arguments overwhelmingly appear to rely on anecdotal evidence and are built on deeply discriminatory stereotypes. So you have this huge ideological divide. On one side, it's an absolute human right. On the other, it's a policy that creates unacceptable risks for other groups.
And it's fascinating to see how that abstract high-level debate at the UN filters all the way down to a single social worker in Switzerland who decides that a parent's refusal to affirm is a risk factor that justifies removing a child from their home.
That is the perfect way to synthesize it. Once you legally establish this expansive right to identity for a minor, the institutions on the ground, the schools, the clinics, feel empowered. They start to see the family and parental authority not as a protective shield for the child, but as an obstacle to be overcome in the name of the child's best interests, as defined by the current ideology of the state.
So after this whole deep dive, it seems clear that this conflict is about so much more than just medicine or pronouns. It is a fundamental high-stakes battle over the legal and political status of the family itself.
That's it exactly. We've traced the history of parental rights from common law through the U.S. Constitution. We've seen how the state can argue for intervention to prevent irreversible harm, using concepts like eugenics. And we've looked at the hard data, like that Ontario curriculum study, that suggests institutions are being captured by an ideology that wants to replace parental guidance with state mandates.
The question of who has the final authority, the parent or the state, is being fought out everywhere, from courtrooms in Europe to budget bills in Washington. And the stakes are so much higher than any single case.
The ultimate insight here, I think, is that once our institutions start to see the family unit as an obstacle to be managed or circumvented, rather than as the foundational building block of society, the vacuum that's created will inevitably be filled by the state. It transforms that private, sacred relationship between a parent and a child into little more than a regulated transaction with a bureaucracy.